How does a no-win, no-lawyer fee work? People hire lawyers on a contingency basis, sometimes known as no-win, no-fee. In other words, you might have seen this on late night television commercials. The lawyer says, if we don't win or if we don't recover for you, we don't get paid. If we don't get money for you, there's no money for us. No lawyer fees for you unless we recover. So how does this work? You sign an agreement with a lawyer that says whatever amount the lawyer recovers, you will pay a portion of that, a percentage typically, to the lawyer. And the remainder goes to you. Now, you'll also want to take a look at whether expenses come off of that. So expenses might be court filing fees, mailing costs, copier costs, things like that. Usually how this works is the lawyer's agreement says, like, let's say you get in a car accident and you have $10,000 in medical bills, a loss of your $30,000 vehicle, and let's also say that after the lawyer works for you, the lawyer gets reimbursement of all your medical bills, the $30,000 for your vehicle, plus, let's say, $15,000 for pain and suffering. In other words, all the pain that you went through, etc. How does that get divided up? Well, it depends on the agreement you signed. In my experience, the agreements have said, first, you get an amount to cover your medical expenses. The lawyer's not going to take a cut of that. Second, you get an amount to cover your vehicle. The lawyer's not going to take a cut of that. What the lawyer does get a cut of is the pain and suffering portion after your out-of-pocket costs are covered. But that's not always the case. And so it's very important to take a look at the representation agreement or service agreement or whatever the lawyer calls the contract that you sign. You might even want to have a second lawyer take a look at this if you're having trouble understanding it. And they're not always clear. So I think it's very reasonable to share the pain and suffering fees with the lawyer. But I would recommend that to the extent you had any out-of-pocket costs for medical expenses or purchasing a new car, I'd recommend you find a lawyer who isn't going to get a piece of that. Because if you had a $30,000 car and $10,000 in medical expenses, and now the lawyer is getting a third of that, you're not going to have enough money to cover your medical bills. You're not going to have enough money to buy the same car you had. So it's very customary for the lawyer to get a percentage of the pain and suffering portion, or the portion after your actual costs are covered. But I would carefully look at your agreement to make sure you're not dividing the rest. What's a reasonable percentage? The most common percentage is 1/3 that the lawyer gets. But I've seen anywhere from 20% to 50%. And that very much depends on how difficult the case is and whether the lawyer is willing to take that. So that's how a no-win, no-fee works with lawyers. Lawyers often call it a contingency fee. And if you are having problems with this, I'd recommend you either contact a lawyer in your state or the state agency that oversees lawyers to get clarification on how something like this works and what your rights are. If you found this video helpful, and you would like more educational videos like this, feel free to subscribe to this channel. If you have other questions, put them in the comments below. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. You can learn more about me at aaronhall.com. And if you'd like to sign up for our free resources, go to aaronhall.com/free. It was great to be with you here today.